California just arrested 3 concealed carry permit holders last month for doing something they thought was perfectly legal, and now they're facing felony charges that could strip away their gun rights forever. Here's the thing: California has the strictest gun laws in America, and they changed again in 2026. Right now, gun owners are getting hit with charges because they're following advice from 5 years ago. One wrong move at a traffic stop, one mistake at the gun store, one misunderstanding about where you can carry, and you're looking at criminal charges. This is happening to law-abiding gun owners just like you, and I'm going to make sure it doesn't happen to you. Number 1. Thinking your California CCW permit protects you everywhere in the state. Here's the scenario. You went through the entire CCW process in your county. You took the training, passed the background check, got your permit. You think you're good to go anywhere in California. So you drive to San Francisco for the weekend, you're carrying concealed, and you stop for coffee. The moment you step out of your car, you're breaking the law. Why? Because California CCW permits are county issued. But there are dozens of locations where even valid permit holders cannot legally carry. And most gun owners have no idea these restrictions exist. Under California Penal Code 25850, carrying a loaded firearm in a prohibited location is a misdemeanor carrying up to 1 year in county jail and a $1,000 fine. But here's where it gets worse. If you're in a gun-free school zone, that's a felony under federal law up to 5 years in federal prison. Just last year, a permit holder in Los Angeles was arrested outside a community college campus. He had a valid CCW. He's now fighting felony charges. Here's exactly what you need to do. First, understand that your CCW does not allow you to carry in any K-12 school, college campus, government building, courthouse, airport, public transit facility, or any location with posted no-gun signage. Second, before you travel anywhere in California with your concealed firearm, check the local county ordinances. Some counties have additional restrictions beyond state law. Third, use the California DOJ's prohibited locations list on their website. Download it, keep it in your car, check it every time you're going somewhere new. Fourth, if you're unsure, leave your firearm secured in your vehicle in a locked container. It's not worth the felony charge. But carrying concealed is only half the battle. The next mistake involves open carry, and this one surprises even experienced gun owners. Number 2. Believing you can open carry anywhere outside city limits. You're out in rural California, maybe you're hiking or camping on public land. You see other people open carrying, so you figure it's legal. Here's the reality. California has some of the most restrictive open carry laws in the nation, and they're full of traps. Open carry of loaded firearms is illegal almost everywhere in California, even in unincorporated areas. Open carry of unloaded firearms is also illegal in most places. The only exceptions are so narrow that most gun owners will never qualify. Yet, I see people getting arrested for this every single month. Under California Penal Code 26350, openly carrying an unloaded handgun in public is a misdemeanor up to 1 year in jail and a $1,000 fine. Under Penal Code 25850, openly carrying a loaded firearm is also a misdemeanor with the same penalties. But if you're in an incorporated city or restricted area, prosecutors can stack charges. One gun owner in Sacramento faced 3 separate charges for one open carry incident, $3,000 in fines, and 18 months probation. Here's what you need to know. Open carry is only legal in California in extremely limited circumstances. First, you can open carry an unloaded handgun while hunting with a valid hunting license in areas where hunting is permitted. Second, you can open carry while engaged in lawful target shooting at an approved range. Third, you can open carry on private property with the owner's permission. That's it. Those are your only legal options. If you're thinking about open carrying anywhere else, don't. Even in rural counties, even on BLM land, even if you see others doing it, the law is clear, and law enforcement will enforce it. Your safest option is concealed carry with a valid CCW or transporting your firearm unloaded in a locked container. Now, even if you never plan to carry your gun in public, this next mistake happens at the gun store, and it's costing people thousands. Number 3. Not understanding California's 2026 purchase and registration requirements. California's gun purchase process is the most complex in America, and it just got harder in 2026. You walk into a gun store, you pick out a handgun, you think you just fill out the federal form and wait 10 days. Wrong. California requires a firearm safety certificate, a background check through the California DOJ, a 10-day waiting period, proof of residency, and as of 2026, additional documentation for first-time buyers. Miss one requirement, provide one wrong document, or misunderstand one question on the forms, and you could be denied, flagged in the system, or worse, charged with attempting to illegally purchase a firearm. Under California Penal Code 27540, providing false information on firearm purchase documents is a felony punishable by up to 3 years in state prison. Under Penal Code 27500, purchasing a firearm without proper documentation is a misdemeanor with up to 6 months in jail and a $1,000 fine. And here's the kicker. If you're denied and try to purchase again without resolving the issue, that's considered a pattern of illegal activity. Prosecutors love to stack these charges. Here's your step-by-step process. First, obtain your firearm safety certificate before you even walk into a gun store. You take a written test. It costs $25. It's valid for 5 years. Second, bring 2 forms of identification: your California driver's license or ID card, plus a utility bill or vehicle registration showing your current address. Third, if you're a first-time buyer in 2026, bring proof of completing a California-approved firearm safety course. Fourth, when filling out the DROS form, the dealer record of sale, read every question twice. Answer truthfully. If you're unsure about a question, ask the dealer to explain it. Fifth, understand that the 10-day waiting period is mandatory, no exceptions. Sixth, when you pick up your firearm, bring the same ID you used to purchase it. Seventh, know that California automatically registers all firearm purchases with the DOJ. There's no separate registration step for most firearms, but buying the gun is just the beginning. How you transport it could land you in handcuffs. Number 4. Transporting your firearm the wrong way in your vehicle. You just bought a new handgun. You're driving home. It's unloaded. It's in the trunk. You think you're following the law. Then you get pulled over for a broken taillight. The officer asks if you have any weapons in the vehicle. You say yes. It's in the trunk, unloaded. The officer asks to see it. You open the trunk, and right next to your handgun is a box of ammunition. Congratulations, you just violated California's transport laws. Why? Because under California law, firearms must be transported unloaded and in a locked container, and the ammunition must be stored separately. Most gun owners get 2 out of 3 right, and that's enough to get arrested. Under California Penal Code 25610, transporting a loaded firearm is a misdemeanor with up to 1 year in jail and a $1,000 fine. But here's where it gets tricky. California defines loaded as having ammunition in the same container as the firearm, even if the ammunition isn't in the gun. Courts have upheld arrests where the gun and ammo were in the same bag, the same case, or even the same trunk space without a divider. One gun owner in Orange County was arrested because his unloaded pistol and a box of 9mm rounds were both in his trunk, no locked container. He spent the night in jail and paid $3,500 in legal fees. Here's exactly how to transport firearms legally in California. First, the firearm must be completely unloaded, no rounds in the chamber, no rounds in the magazine, nothing. Second, the firearm must be in a locked container. A locked container means a secure container that is fully enclosed and locked by a padlock, key lock, combination lock, or similar locking device. Your glove compartment does not count. Your center console does not count unless it locks. Third, store ammunition in a completely separate locked container. If you only have one locked container, put the gun in it and put the ammo loose in your trunk, separate locations. Fourth, if you have a CCW permit, you can transport a loaded firearm on your person or in a locked container within the vehicle. Fifth, when stopped by law enforcement, immediately inform the officer that you have a firearm in the vehicle, where it's located, and that it's unloaded and locked. Do not reach for it. Let the officer secure it if necessary. Now, even if you follow every rule I just gave you, California's 2026 legislative changes just added new traps. Number 5. Ignoring California's new 2026 gun laws that just took effect. Every year, California passes new gun legislation. Most gun owners hear about the big changes: assault weapon bans, magazine restrictions, but the laws that get people arrested are the small ones buried in 500-page bills that nobody reads. In 2026, California enacted several changes that directly affect how you purchase, possess, and carry firearms. Some of these laws have mandatory minimum sentences, some create new prohibited locations, Some change how you must store firearms at home, and almost nobody knows about them because they weren't headline news. You're expected to follow laws you've never heard of, and ignorance is not a defense. Here's what's new and dangerous. California now requires microstamping for all new semi-automatic handguns sold in the state. If your gun doesn't have it, it can't be sold. Violation for dealers is a misdemeanor. California expanded the list of prohibited persons to include anyone convicted of certain misdemeanors in the last 10 years, even if you bought guns legally before. Now you're a prohibited person. California also added new sensitive place restrictions. Certain parks, public demonstrations, and places of worship now prohibit concealed carry even with a valid CCW. Finally, the state increased penalties for improper storage if a minor gains access to your firearm. Here's what you must do immediately. First, if you purchased any firearms before 2026, verify they're still legal to possess under new definitions. Some previously legal configurations are now restricted. Second, review the updated list of sensitive places where CCW is prohibited. The California DOJ website has the complete list. Download it today. Third, if you have firearms at home and anyone under 18 lives there or visits regularly, you must store firearms in a locked container or with a locking device. Fourth, check your own criminal history. If you've had any misdemeanor convictions in the last 10 years, consult with a firearms attorney to verify you can still legally possess guns. Fifth, stay updated on California gun laws. Subscribe to this channel because I cover every new change the moment it's signed into law. But here's where most people mess up. They think they're storing their guns legally at home, but this next mistake could cost them everything. Number 6. Improper firearm storage when children are present. You're a responsible gun owner. You keep your guns in a safe, but your teenage son has friends over, and one of them asks to see your gun collection. Your son knows the safe combination because you taught him gun safety. He opens the safe, shows his friend an unloaded pistol. The friend takes a photo, posts it on social media. A parent sees it, calls the police. Now you're facing criminal charges for allowing a minor access to your firearms. This exact scenario happened in San Diego in 2025. The gun owner thought he was being a good parent by teaching his son responsibility. The state charged him with criminal storage of a firearm. Under California Penal Code 25100, criminal storage of a firearm in the first degree, when a child gains access and causes death or great bodily injury, is punishable by up to 3 years in state prison and a $10,000 fine. Criminal storage in the second degree, when a child gains access but no injury occurs, is a misdemeanor with up to 1 year in jail and a $1,000 fine. But here's the devastating part. If charged, you can also lose custody of your children. CPS gets involved. Your name goes in the system. One storage mistake can destroy your family. Here's how to protect yourself and your family. First, all firearms must be stored in a locked container or with a California-approved firearms safety device when not in your immediate possession and control. Second, if anyone under 18 lives in your home or regularly visits, this is mandatory, no exceptions. Third, locked container means a safe, lockbox, or gun cabinet that cannot be easily broken into. A cable lock through the action counts as a safety device. Fourth, do not give minors the combination or key to your gun storage, even if you trust them completely. California law holds you responsible if they access the firearms. Fifth, if you're home and carrying your firearm on your person, or it's within your immediate reach and control, storage requirements don't apply. Sixth, teach your children gun safety, but make it clear they are never to access your firearms without your direct supervision. Now, even if you nail storage, this next mistake happens when you're trying to be a good friend. Number 7. Loaning or giving a firearm to a family member or friend without going through an FFL. Your brother-in-law is going through a rough time. He's been getting threats from an ex-employee. He asks to borrow one of your handguns for protection. You've known him for 20 years. He's not a criminal. You hand him your Glock 19, tell him to be safe, and send him home. 3 weeks later, police show up at your door. Your brother-in-law was pulled over with your gun in his car. Now you're both facing charges. Why? Because California requires almost all firearm transfers, even temporary loans between family members, to go through a licensed dealer with a background check. Most gun owners have no idea this law exists, and it's one of the most commonly violated statutes in the state. Under California Penal Code 27545, transferring a firearm without going through a licensed dealer is a misdemeanor punishable by up to 6 months in jail and a $1,000 fine. But if the person you transfer to is a prohibited person, even if you didn't know, you're looking at felony charges under Penal Code 27500, up to 3 years in state prison. One gun owner in Fresno loaned a pistol to his cousin for a weekend camping trip. The cousin had an old DUI conviction that made him a prohibited person. Both were arrested. The gun owner served 18 months. Here's what you need to know about legal transfers. First, almost all firearm transfers in California must go through a licensed FFL dealer who conducts a background check and processes the draw's paperwork. Second, there are only a few exceptions. Transfers between immediate family members, parent, child, grandparent, grandchild, spouse, loans at a shooting range or while hunting if you remain present, and loans for up to 30 days if there's an immediate threat to the person's life. Third, even for family transfers, you must complete a report of operation of law or intrafamilial handgun transaction form and submit it to the DOJ within 30 days. Fourth, if someone asks to borrow your gun, tell them you'll meet them at an FFL to do it legally. Yes, there's a fee. Yes, there's paperwork, but it's better than prison. Fifth, never assume someone is legally allowed to possess firearms. Let the background check confirm it, but transfers aren't the only way to accidentally become a felon. This next mistake involves magazines. Number 8. Possessing, importing, or manufacturing high-capacity magazines. You moved to California from Arizona last year. You brought your gun collection with you, including several 15-round magazines for your Glock. You figure magazines aren't firearms, so they're not a big deal. Wrong. California bans the possession of magazines that hold more than 10 rounds. You're at the range, you're shooting with your 15-round mag, and a range officer notices. He's required to report it. Police show up at your home with a warrant. They search your gun safe and find 6 more high-capacity magazines. Now you're facing multiple counts of illegal possession. This happened to a gun owner in Sacramento who moved from Nevada. He had no idea his magazines were illegal. He's now fighting 6 misdemeanor charges. Under California Penal Code 32310, manufacturing, importing, selling, or giving away high-capacity magazines is a misdemeanor punishable by up to 1 year in jail and a $1,000 fine. Simple. Possession is also a misdemeanor with the same penalties. But here's where it multiplies. Each magazine is a separate count. If you have 10 high-capacity magazines, that's 10 separate charges, potentially 10 years in jail and $10,000 in fines. Courts can run these consecutively. One gun owner in Los Angeles was sentenced to 36 months probation and $4,500 in fines for possessing 7 15-round magazines. Here's how to stay legal. First, California law defines a high-capacity magazine as any ammunition feeding device with the capacity to accept more than 10 rounds. This includes detachable magazines, fixed magazines, and tubular magazines for rifles. Second, if you move to California from another state, you cannot bring high-capacity magazines with you, period. You must leave them behind, sell them, or destroy them before entering California. Third, if you owned high-capacity magazines during California's brief Freedom Week in 2019 when possession was temporarily legal, you may still possess them, but you cannot buy, sell, or import new ones. Fourth, permanently modify any high-capacity magazines to accept only 10 rounds by installing a rivet, epoxy, or other permanent blocking device. Fifth, when purchasing magazines, verify they're California compliant. Some look identical to standard capacity but have internal limiters. Sixth, never order magazines online from out-of-state retailers who ship to California. That's importing, and it's illegal. Magazines are one thing, but this next mistake involves the guns themselves, and it's getting people arrested every single day. Number 9. Owning an unregistered assault weapon or building one without realizing it. You bought an AR-15 California years ago when it was legal. You registered it properly, then you decided to upgrade it. You added a new pistol grip, a collapsible stock, maybe a flash suppressor. You didn't change the lower receiver, so you figure it's still the same registered gun. Wrong. Under California law, adding certain features to your rifle can transform it from a registered assault weapon into an illegal configuration or create an entirely new unregistered assault weapon. You're now in possession of an illegal firearm, and you don't even know it. This is happening right now to gun owners who think they're following the law. One modification, one new part, and you've committed a felony. Under California Penal Code 30605, possession of an unregistered assault weapon is a felony or misdemeanor wobbler offense, punishable by up to 3 years in state prison and a $10,000 fine. Manufacturing an assault weapon, which includes assembling one from parts, is a felony with the same penalties. But here's the worst part. If convicted of an assault weapon offense, you lose your right to own any firearms for life. You also face federal prosecution under the National Firearms Act. One gun owner in Riverside modified his registered AR-15 with a standard magazine release. He was arrested during a traffic stop. He lost his entire gun collection and served 18 months in prison. Here's what you absolutely must understand. First, California defines assault weapons by specific features. For rifles, this includes a detachable magazine combined with any of the following: pistol grip, thumbhole stock, folding or telescoping stock, grenade or flare launcher, flash suppressor, or forward pistol grip. Second, if you own an AR-15 or AK pattern rifle, it must be configured as either a registered assault weapon, if registered before deadlines, a featureless rifle no prohibited features, or have a fixed magazine that requires disassembly to reload. Third, never modify a registered assault weapon without checking if the modification is legal. Even swapping parts can create a new illegal configuration. Fourth, if you build a rifle from parts, ensure it complies with California's assault weapon laws before assembling it. Fifth, use the California DOJ's assault weapon identification flowchart on their website. It walks you through whether your configuration is legal. Sixth, when in doubt, consult a California firearms attorney before making any modifications. We're almost done, but this final mistake is the one I see most often, and it involves something every gun owner does. Number 10. Traveling out of state with your California firearms and coming back illegally. You're driving to Nevada for a shooting competition. You bring 3 handguns, your AR-15, and plenty of ammunition. You compete, you have a great time, you're driving home. At the California border, there's an agricultural inspection station. The inspector asks if you have any firearms. You say yes. He asks to see them. You show him your AR-15. He notices it has a standard magazine release, legal in Nevada, illegal in California unless it's a registered assault weapon or featureless. You're detained. Your guns are confiscated. You're facing felony charges. Why? Because when you cross back into California, your firearms must comply with California law the moment you enter the state. Most gun owners don't realize that what's legal in Nevada, Arizona, or Oregon can get you arrested the second you cross the California border. Under California Penal Code 30600, importing an assault weapon into California is a felony punishable by up to 3 years in state prison. Under Penal Code 32310, importing high-capacity magazines is a misdemeanor with up to 1 year in jail and a $1,000 fine. But here's the real danger. Border Patrol and agricultural inspectors at California entry points are trained to spot illegal firearms. They will search your vehicle, they will confiscate non-compliant guns, and they will arrest you on the spot. One gun owner returning from Arizona with 4 15-round magazines was arrested at the border, spent 2 nights in jail, and paid $6,000 in legal fees to get the charges reduced. Here's how to travel legally. First, before leaving California with firearms, verify that every gun and magazine you're bringing is California compliant for your return. If you're bringing an AR-15, it must be featureless or have a fixed magazine, no exceptions. Second, do not purchase firearms, magazines, or parts in other states and bring them back to California. All firearm purchases must be shipped to a California FFL and go through the draws process. Third, if you're moving to California permanently, research every single firearm and magazine you own. Sell or leave behind anything that's not California compliant. Fourth, when traveling through California to another state, you're protected by the Firearms Owners Protection Act, but only if your firearms are unloaded, locked, and inaccessible, and you're traveling directly through without stopping except for gas or rest. Fifth, keep documentation of your California firearm registrations in your vehicle when traveling. Sixth, if you're unsure whether your guns are compliant, leave them home. It's not worth the felony charge. Let's recap the 10 deadly mistakes that could land you in legal trouble. First, thinking your CCW protects you everywhere it doesn't, and prohibited locations will get you arrested. Second, believing you can open carry outside city limits. You can't. It's illegal almost everywhere. Third, not understanding 2026 purchase and registration requirements. Missing one document can flag you in the system. Fourth, transporting firearms with ammunition in the same container. That's a loaded firearm under California law. Fifth, ignoring droit de chance advogé legislative changes, new sensitive places, new prohibited persons, new penalties. Sixth, improper home storage when children are present. This destroys families and costs you custody. 7. Loaning guns to family without an FFL transfer. Even your brother needs a background check. 8. Possessing high-capacity magazines. Each one is a separate criminal count. 9. Owning an unregistered assault weapon or building one accidentally. This is a life-changing felony. 10th, traveling out of state and returning with non-compliant firearms. Border inspections will catch you. Any one of these mistakes could cost you $10,000 in legal fees, years in prison, or your right to own firearms forever. California doesn't care if you didn't know the law. You're expected to follow it. Don't let confusion about California gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. Hit that subscribe button right now. I break down complex gun laws every single week so you can own and carry with complete confidence and zero fear of arrest. Next video, I'm covering the Florida gun laws in 2026 that every gun owner must know.